Good afternoon, everyone. Welcome to the first lecture of Judicial Services Examination Lecture Series 2021. It is an honor for me to welcome on behalf of JGLS our guest speaker for today, Honorable Mr. Justice Bhamar Singh, former Judge, Allahabad High Court, who will be delivering the lecture on the Constitution of India 1950, a judicial perspective. Honorable Justice Singh joined the UP Judicial Service as Judicial Magistrate First Class in 1970. He was promoted as Civil and Assistant Sessions Judge in 1976. He got his next promotion in December 1979 and was appointed as Additional District and Sessions Judge in the UP Higher Judicial Service cadre. He presided over a special court of CBI Dehradun from 1983 to 1987 and decided many critical cases, including murder trials investigated by the Central Bureau of Investigation. He was appointed on deputation as Additional Registrar Lucknow Bench from 1987 to 1992 and then elevated as Registrar. The post is now designated as Registrar General of Allahabad High Court, where he worked from 1992 to 1994. In November 1994, he was appointed as District and Sessions Judge and worked until 1998. He was appointed as Registrar General of the Supreme Court of India in February 1998. He was elevated as a judge of Allahabad High Court in March 1999, and he continued to preside over the High Court bench at Lucknow up to January 2007. In February 2007, he was appointed as President of the UP State Consumer Commission, Lucknow. During his tenure as High Court Judge, the Governor of UP nominated him as member of the Meerut University Governing Council for 2 terms. He was also appointed as Chairman of UP Judicial Training and Research Institute, Lucknow, in June 2012 and continued his office for 2 years. Currently, he is the Honorary Chairman of the Tribunal of the Arbitration of Dr. Ram Manohar Lohia National Law University, Lucknow. He is also associated with the group of institutions of the Sunshine Educational and Development Society, Greater Noida, as Director General. Justice Mr. Singh has himself gone through the process of appearing for the State Judiciary Examination of Uttar Pradesh. Today, His Lordship will be sharing his insight on the subject, the Constitution of India 1950. His Lordship will discuss important questions and how to approach them. His Lordship has also kindly agreed to share with us the perks and benefits that are enjoyed by judicial officers in India. I now humbly invite Justice Mr. Singh to deliver the lecture, after which I will be taking up your questions from the comment section in the last 15 minutes. Justice Mr. Singh, over to you.
Thank you, Trapti, for taking me down the memory lane of as long as 51 years by now. So, dear friends, good morning to all of you. It is indeed a pleasure to be invited to Jindal Global School of University. And credit goes to Trupti, who has been my student, a brilliant student. And I believe that she is a brilliant teacher now. God bless her. So friends, as just mentioned by Trupti, assistant professor in Jindal Global University. I'll be taking today's interaction with you in 2 parts. The first part will pertain to the judicial services in the country. More emphasis will be given to the state judicial service, because that is said to be the backbone of our Indian judicial system. So friends, there are 3-tier judicial system in our country. As you know, at the apex level is the Supreme Court of India, which has 33 judges. The judges to the Supreme Court are appointed by the President of India on the recommendation of the Collegium of the Supreme Court. And if I say in comparative terms, it is the easiest procedure of appointing the Supreme Court judges. But the policy is very difficult. Policy is not as easy as the procedure is. You know, the present government in its first term got an enactment passed by the parliament that the judges to the High Court and the Supreme Court will be appointed by the Indian Judicial Commission. But fortunately or unfortunately, that act of the Indian Judicial Commission was quashed by the Supreme Court of India on the basis of the fundamental feature of the Constitution of India. As a matter of fact, it is nowhere mentioned that there will be a collegium system in the Indian judicial system. But it is derived, the independence of judiciary is derived from many articles of the Constitution of India, particularly Articles 20 to 26 and Article 32. We will be dealing with the provisions of these two articles in our later part of the discussion. First, to begin with, as I mentioned earlier, the judiciary in India is of 3-tier, and at the apex level is the Supreme Court of India. In Supreme Court, the rule of precedence is, it is a rule which has been formulated by the Government of India in consultation with the Supreme Court. The judges in the high courts who have put in more than 5 years of service and are of 55 years of age are considered to be appointed as the Supreme Court judges. A few of the Supreme Court judges have in the past also been appointed from amongst the members of the bar, and at present Mr. Justice Nagendra Rao and Mr. Justice U. Lally are the examples of such appointments. And in the past, there have been many advocates who refused the ship of Supreme Court. I can name them Justice Mr. N.A. Palkiwala and Sitalwad, and a few more, but it is the past story now. The judges who are offered the Supreme Court judgeship, generally, with 1 or 2 exceptions, agreed to be appointed. Friends, at the second tier comes the High Court in every state, with exceptions. For example, there is one High Court for the states of Punjab and Haryana, as also the Union Territory of Chandigarh. It is an arrangement. It depends upon the central government. It can create a new High Court. As in the Northeast region, there was 6 benches of Assam High Court, but now separate High Courts have been created there too. Friends, the High Court judges are appointed from amongst the cadre of the district judges and from the advocates of the High Court Bar Association, as also the District Bar Association. The rule of precedence says that advocates, not district judges, who have put in 10 years of service, and the district judges will be appointed to the bench of the High Court. The minimum age for the advocates is 45 years, but there is no age bar for the district judges because they come by way of seniority. Friends, then the third tier is that of the district judiciary. And in the district judiciary, there are two cadres. One is that of the higher judicial service, which includes the district judges and additional district judges. And to this, again, there are two sources of appointment. One is from the advocates, the judges, the advocates who have put in 7 years of service and who are not less than 35 years of age will be eligible to appear for the higher judicial service examination. And the other source is that of the provincial judicial service, which will be the main topic of discussion of today's lecture with you. Friends, provincial judicial service was introduced by the Britishers when they were ruling India. And at the initial stage, the district magistrate would appoint the magistrates and the munsifs. Munsif is a synonym of judge, and it is a Urdu word. But now across India, across the entire country, this word instead of this, civil judge junior division has been incorporated in all the judicial services of the states. Friends, in past, that is 40, 50 years back, the provincial judicial service, where you can compete now, because to compete for the higher judicial service, you have to be of 35 years age, and to go directly to the High Court bench, you have to be 45 years of age, and then for Supreme Court, you have to be of 55 years of age. So there is a long period to go through that source. So the only source of joining judicial service as of now, that is soon after you obtain the law degree, you can appear for a provincial judicial service. And as I mentioned, provincial judicial service 40, 55 years back was not as attractive as it is today. The reasons were that there were no perks at all at that point of time. And salaries were also less than that of the IAS and IPS police officers, Indian police officers. And if I remember exactly, my memory does not deceive, then I remember that even the professors of the universities, particularly the residential universities, were getting the higher remuneration than to the civil judges. Because there was a prejudice against that judicial service. And in this very context, I would like to mention that even the ICS officers, before IAS was the cadre of ICS, the ICS officers who were appointed by the British government through Governor General of India. The services of the Indian civil services, if was not considered to be, let me read after this sentence, if the officers of the Indian civil service were not considered to be amenable to the government's advice, if they created some kind of adamant attitude towards the government, if they stuck to the rules, if they followed the rules and by rules or laws and bylaws, then they were considered to be uncomfortable ICS officers to the government. So such officers were sent to the judiciary. And these officers were not even law graduates. But in accordance with their seniority, they were elevated to the High Court because they adorned the office of the district judge. And at that point of time, the district judges were eligible to be appointed as High Court judges. And once they were High Court judges, they were also eligible to become the Supreme Court. So in due course of time, 5 such judges who were not law graduates adorned the bench of Supreme Court. So it is indeed, it seems to be strange in the present era, but it is a fact. And it is mentioned in a book written by an American author on Supreme Court of India, that these judges interacted with the author of that book, the Supreme Court of India, but they requested that their names may not be disclosed. So I will not be disclosing their names, but 3 of them, it is interesting to learn that 3 of them, after their retirement from the Supreme Court, went to England, studied law, and then started practicing before the House of Lords and other tribunals. So coming back to the Provincial Judicial Service, the State Public Service Commission, which is there in every state, conducts the competitive test, and all law graduates having the age group of not less than 21 years up to 33 years, and in some states it is 35 years also. There is some relaxation for the reserved category candidates. And after the test is conducted and the candidates qualify as per the procedure of the State Public Service Commission, they are asked to appear before the interview board, and every board in the state is chaired by a High Court judge who is a sitting judge normally, and he acts as the chairman of the board. And I remember 50 years back, only the retired judges were invited to be one of the members of the board. And I remember that when I was interviewed, a former Chief Justice was invited, but he was not the presiding officer of the board. Only the chairman of the Public Service Commission was authorized and entitled to preside that panel. But now everything has changed. Over a period of 50 years, the High Courts and the Supreme Courts, they have issued guidelines that since it pertains to the appointments in the judiciary, therefore, the judge of the High Court should play an important role in the selection. So friends, there was a prejudice with the government officers against the Indian Judicial Services, the Provincial Judicial Service. And the reason was that judges would always stick to the law. They would pass unfavorable orders against the government, adverse orders against the government, and the government was always not very happy with the judges. But in due course of time, and let me also share one anecdote with you. Whenever the politicians, the ministers were asked to ameliorate the service conditions of the judges, they did not bother for it. Once a convention, that is a conference of the judges in the district was convened in the Uttar Pradesh, and the venue was the district Agra. I was also posted there at that point of time, and very elaborate arrangements were made to welcome the Chief Justice of India and the Chief Minister of Uttar Pradesh. The Chief Justice of India, Mr. Justice I.V. Chandrachud, the father of the present Dhananjay Chandrachud of the Supreme Court, he was the Chief Justice of India. He came to address the strong gathering of some 700 judges. And during his discussion, he recommended to the Chief Minister that the service conditions of the judges in the district should be improved considerably. And he made very useful discussions insofar as the judicial service was considered. But it was not taken in the right earnest by the Chief Minister, Mr. Vishwanath Pratap Singh. He said that the value of a painting is not assessed by the cost of the colors and the materials and the labor put in it. So he outrightly rejected that suggestion, but and it was on account of this fact that the other governments too ignored the rightful claims for better pay scales and better perks of the judges in the district. However, and there was one more prejudice against the judges of all the tier, of all the levels of the Indian judiciary, that is High Court, Supreme Court, that the executive officers of the central government, of the state governments, they would always say that the judges enjoy very many holidays. But they would, it was a fact that Supreme Court was closed for 2 months in summer vacation, for 15 days in the winters, and likewise, High Court was also closed for 1 month. The district courts were also closed for 1 month. I used to avail 1 month summer vacation and 15 days winter vacation when I was in the district. But slowly, these holidays were curtailed. But even now, the Supreme Court avails of some six weeks of summer vacation, and likewise High Court to district judges too. And there is a justification of it. When much hue and cry was raised some 15 years or so back, the then Law Minister, Mr. Hansraj Bhardwaj, came to the rescue of judges. And he narrated in detail that the judges have to do very strenuous work, very hard work. And the routine of the judges is they get up in the morning for the files. After a cup of tea, they sit in their residential office at 5 o'clock in the morning. After preparing the case, then they dictate the judgment and keep on dictating up to 9:30. Then hurriedly go to court and work there from 10 to 4:30 p.m. And then after the court, then sign the orders, etc. It was no doubt a fact that judges, after finishing their work, come at home by 5 or 5:30 p.m. And that way one can say that the judge's life is not as strenuous as that of the lawyers or the corporate lawyers or the law firm partners, etc. But otherwise, there is a lot of work. And let me share with you as to how the situation took a turn for improvements in the service conditions of the judges. Justice Ranganath Mishra was the Chief Justice of India from September 1990 up to the November 1991. And it was to the good fortunes of the judicial services that he became the Chief Justice of India, because Justice Mukherjee died prematurely in London while taking his heart ailment treatment. Had Justice Mukherjee not passed away prematurely, perhaps Justice Rangnath Mishra would not have become the Chief Justice, because Mukherjee had a longer tenure than that of Mr. Mishra. Justice Rangnath Mishra, I had the experience of sharing my thoughts with him, not once but many a times. And when I was the Registrar General of India, he was the member of the Rajya Sabha, and he used to frequently call me to send some drafts for more amelioration of the service conditions of the judges. It was my good luck to have interacted with him a number of times. So I can say that to the fortunes of the Indian judiciary, he became the Chief Justice of India for more than a year. During his tenure as Chief Justice of India, he took a suo motu cognizance of the matter that the service conditions of the judges in the district were miserably below the standard. And therefore, he appointed a one-man judicial commission, which is called Justice Jagannath Shetty Commission. Justice Jagannath Shetty was the former judge of Supreme Court of India. He hailed from Bangalore, but in due course of his service, he came to be as the Chief Justice of Allahabad High Court, and then from there he was elevated to the Supreme Court. So Justice Jagannath Shetty toured the entire India. He went from one state to another and interacted with hundreds of, rather thousands of judges in that district. He, from the close quarters, came to learn about their problems and then recommended, after 2 or 3 years, better pay scales of the judges in the district. And not only that the better pay scales were recommended, but he also recommended that judges should be entitled to other perks also. And that report of Justice Jagannath Shetty was accepted, and it was mandated to the central government and to all the state governments. They were all joined as a party to that petition. And the Supreme Court issued a mandamus instructing all the state governments and the central government to implement the pay scales recommended by Justice Jagannath Shetty Commission. Friends, since then, the better pay scales have been applied in case of the judges in the district. And now the table has turned so as to make the judges in the district at a higher pedal than that of the IAS and IPS officers. Now they get, besides salary of around 1 lakh per month, that is in cash, they are entitled for free house. If I give an instance, if Trupti would have been a judge in Noida, where does she stay? she would have been entitled as a judge to draw rupees 40,000 per month as the house rent allowance. It's a good amount, and it is added along with the salary. Besides rent-free allowance, judges get the dress allowance also per month, and I'll accumulate them because it will take a longer time to tell about the figures, but they are very encouraging figures. And dress allowance, then furniture allowance to furnish the house, then electricity up to a certain extent, of course. It is the reimbursement is up to 50% of one uses it. And then free landline phone with broadband, free mobile SIM with unlimited data, then sumptuary allowance, then LTC entitlement, that is the family of a judge. He or she, along with 2 children, can go to anywhere in the country and can avail of the expenditures, traveling expenditures. It is also a use sum. Then if somebody joins with master's degree in law, then he is entitled to rupees 8 to 10,000 per month as the master's degree allowance. Then car allowance. In many districts, official cars have been provided. And there is an option that if somebody doesn't want to avail of that facility, he can take reimbursement of the petrol, ranging from 50 liters to 75 liters. It comes to 5 to 10,000 rupees per month. Then, friends, medical allowance. Then a judge has to maintain his office at the residence also. Then residential office allowance is also sanctioned. Then free library at residence in the office. Then a free laptop with printer, etc. So friends, this all, if arithmetically calculated, it comes to somewhere between 25 to 30 lakhs per month. If I compare it with 40, 50 years back salary, then it is nothing. That was nothing as compared to this. 25, 40, 25, 30 lakhs rupees is a handsome sum if considered in terms of the economy. So friends, it has become a very attractive service. 2 PNs are also provided. They help you at home also. And much more above all is the salutes you get. You sat on a higher pedal, and everyone whosoever comes to your court will have to bow. And I remember an anecdote in 1969 when President V.V. Giri was elected as President of India. An election petition was filed in the Supreme Court. And circumstances, or say the allegations in the petition were such that Giri has to be asked to appear before the Supreme Court. And we may remember that President is the appointing authority of the Supreme Court judges, and he is the #1 citizen in India. But since it was a dispute pertaining to his election, so he was asked by the Supreme Court to appear. Then a very interesting disputable point arose as to what will be his level. After all, he is above the Supreme Court judges because he is President of India. And at that time also, oath had been administered to him. He was the President of India, staying in the Rashtrapati Bhavan. So what was arranged for by the Supreme Court, that a higher level platform got constructed for him to sit and state his submissions, make his statement. But still, the level of his platform was kept lower to the dais of the judges, because there the judges had a higher pedal. So that height makes a difference. And I remember one more anecdote of Japan. There, the Supreme Court was being constructed, and the judges of the Supreme Court raised such a layout plan of the building that its dome of the building, like that of the Supreme Court's dome, was going high to the dome of the parliament there. Parliamentarians there raised hue and cry that how come the Supreme Courts can go hard to the parliament, because parliament is supreme, it can formulate any law it likes. So, and that was referred to the king of Japan, because their kingship is there. Then a mutual arrangement was arrived at between the parliamentarians and the Supreme Court Chief Justice, that let it be kept 6 inches below that of the parliament's dome. So it is how, the judges' position when they sit in the court at a higher level, then it makes all the difference. So friends, this the entire background and as to how the service conditions of the judges improve. And I may also tell you that as judges of the Provincial Judicial Services, you will be entitled to become member of the higher judicial service, then become district judge, and as per seniority, to become as High Court judge, and as High Court judges per seniority to go to the Supreme Court. So this and even after, I tell you very interesting facts also, that even after retirement, you enjoy the pensioner benefits, and pension is always half of what you have been drawing at the time of your retirement. And there are many countries in Europe where the judges get their pension equivalent to their salary as they were driving on the last day of their tenure. It's wonderful indeed. And America is one where judges never retire. Once appointed, they stay up to the last breath of theirs. And a few months back, I read that a judge who was 103 years old was hospitalized in America. And from hospital itself, he was delivering judgment and judgments after one another. So, and possibly by the time you will come join Judiciary and go to the High Court, Supreme Court, maybe that the judges get their pension as the last pay drawn. It is indeed, but even if it is not, then the half pension or the pension equivalent to the half of the salary of the last pay drawn is more than enough, because by then the children get settled, and only two of the judge and his spouse or her spouse are left to enjoy the life. So in all, whether in all, the judiciary, judicial service is really excellent. And if asked to me, then I'll say that it is better than all other services. So friends, this was all about the attraction you must have towards the judicial service. And when the Amarchand Bangaldas firm of the solicitors and other solicitor firms, they pay rupees 15 lakhs or around 15 lakhs, as I have heard. So as compared to the member of, as compared to being the member of a firm, then it is always better to come to the judicial service. Of course, in practice, you can earn a lot more, but you have to wait for 10, 15 years. You must be remembering that people like Katie Tulsi, who came along with me in Jindal Global University to have a discussion on some topic I'm forgetting. Principal and many more who are in the limelight, who are in the first row of the Supreme Court Bar Association. They have been earning some 35 lakhs rupees per day. I repeat, per day. So to reach that level of earnings, it will take at least 1 decade or maybe more to earn that much. But now, to summarize this part of my interaction with you, I would inspire you to join the judicial service because there is no age limit. Uh, Otherwise, for higher judicial service, you have to be of 35 years age to appear in the higher judicial service examination. And as if you join as a civil judge, then there is no limitation. I was below 35 years of age when I was promoted to the higher judicial service. Had I been practicing law, I would not have been entitled to become additional district and sessions judge. And you know, the judges are very powerful. They own when they sit on civil side, they decide disputes worth crores of values. And when they sit on criminal side, they pass sentence to the convicts ranging from 1 month to life imprisonment and even death sentences. So friends, the judicial service is considered to be excellent service. And for girls, there is a special reservation. In Uttar Pradesh, there is a reservation up to 25% for the girls. And it is besides the general reservation. When I was chairman of the Uttar Pradesh Judicial Training and Research Institute, where the civil judges would come for their training, I found out of 80 candidates of that batch, 40 were the girls. So that way, for girls, it is considered to be a wonderful service. And for others also, for male, female, there is hardly any difference. But in all, the service is wonderful. So friends, now if we talk about the Constitution, our Constitution of India was implemented on 26 January 1950 after debate of the Constituent Assembly for 2 years, 11 months, and 27 days. And there were very interesting facts of those days, but they cannot be gone into. And otherwise also they have become now the stories of past. Friends, I wanted to discuss you with many good topics like fundamental rights, directive principles, the preamble of the Constitution, and the Election Commission of India, the right to liberty, live in liberty, and right to equality. But because of the constraint of time today, I'll confine myself to the judicial powers of the High Court and the Supreme Court. Friends, there is Article 32, which authorizes the Supreme Court to issue writs of certiorari, prohibition, mandamus, quo warranto, and habeas corpus. But the power of the Supreme Court is limited in that respect. It can issue these writs only if someone's fundamental rights have been violated. But the High Court, under Article 226 of the Constitution of India, exercise more powers than the Supreme Court. It exercises its powers in respect of any violation of law or constitution. So, High Court has powers to issue writs of certiorari, writs of prohibition, writs of mandamus, quo warranto, and habeas corpus. Friends, I take them one by one because that is called the power of judicial review of Indian judiciary. And it is very important power. It was under this power that the enactment pertaining to the creation of the Indian Judicial Commission was questioned by the Supreme Court. And not this, but many other acts have been questioned by the Supreme Court over the 75 years of independence. Friends, to discuss them in short, let me take the writ of certiorari. A body of persons having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially, it is important. If it is a judicial obligation or a quasi-judicial obligation or acts in excess of the legal authority, then a writ of certiorari can be issued. Friends, there should be a dispute between two parties, and one party should say that the legal authority exercised by the inferior authority was in excess of the authority which could have been exercised by it. Friends, when Maharashtra used to be the Bombay state of Bombay, then some land was acquired for a public purpose by the government of Bombay long back, and the landowners had filed a petition in the High Court that the state government, or say the land acquisition officer, has not decided their objections in accordance with the judicial procedure. But since there was no judicial procedure, neither it was a judicial authority, the High Court rejected that petition. But subsequently, when some traffic routes where the private buses were being plied by the private owners were nationalized by the Maharashtra government, when it had the name had been, nomenclature of the state had been changed, then the objections were invited from the pliers, private pliers, and those objections were supposed to be disposed of in accordance with the judicial procedure prescribed. The government, however, rejected their objections without going into the merit thereof. The High Court interfered, issued a writ of certiorari, quashed the orders, and then directed to act judicially. Friends, Lord Hewitt of House of Lords in 1924 has laid down a very interesting and very important principle of law, and it was that justice should not only be done, but it should appear to have been done. And the same principle was followed by our Supreme Court in Gulapalli case versus Andhra Pradesh High Court, when a roadways scheme was launched by the Andhra Pradesh High Court, and the objections of the private lawyers were rejected without going through that procedure. Friends, let me also give one more example where it would have been possible for the High Court to interfere. In Bihar, the result of high school was quashed because there were complaints of mass copying. Since it was to the disadvantage of those who have already passed that examination, it was considered by the High Court of that state that those who were adversely affected, that is, who have already passed the examination, were not given a right of hearing. And since principles of natural justice were violated, the order was quashed. But in a similar case, where the result of the intermediate board had not been announced, the examination was quashed. The High Court held that since nobody has been declared as passed, the no right to accrue to any student to challenge the question. So this is the difference where the High Court and the Supreme Court, High Court did not grant the relief, then Supreme Court will come to the rescue of those whose rights have been violated. Friends, you must be remembering the Menka Gandhi case, and if not the case, perhaps the name of Menka Gandhi must be known to you. She was a minister in the erstwhile BJP government, and she was the daughter-in-law of late Prime Minister Indira Gandhi. When Indira Gandhi was the Prime Minister and Menka Gandhi was living with her after death of Menka's husband, she expressed her desire to join some political party, and some differences arose between the two, that is Indira Gandhi and Menka Gandhi, as a result of which Menka Gandhi left the Prime Minister's place, and in retaliation, the passport of Menka Gandhi was revoked by the passport officer. She filed a petition before the Supreme Court, and the Supreme Court held that since Menka Gandhi's passport had been revoked without hearing her or without giving a notice to her, the revocation order was held to be unjustified and it was quashed. It was a turning point, friends, when the importance or much significance was extended to the fundamental right to live with liberty, travel abroad, travel from one place to another in India, etc. Friends, the writ of certiorari and all writs, they are discretionary writs. They cannot be invoked if some alternative remedy is available. And the crucial point to be kept in mind is that only that order can be challenged by way of filing a writ of certiorari, in which either the authority below has not passed an order on merit, exercising its judicial or quasi-judicial power, or it has exercised in excess of the power vested in it. Friends, if there is a violation of principles of natural justice, it is called audi alteram partem, that is notice and opportunity of hearing, then High Court and Supreme Court can interfere. with an order. Friends, such an order of judicial authority, which is under challenge, should be a reasoned order, as has been advised more than once by the Supreme Court and High Court. Both the point to be taken into consideration is that it should not be a biased order, it should not be a prejudiced order of the passing authority. And the principle of natural justice. Friends, the second issue is that of prohibition, and it has a connection with the writ of certiorari. If a case is pending before an inferior court and the court doesn't have the power to entertain it or decide it, then the superior court can pass an order restraining the inferior court from proceeding further. And if some order has been passed already, then it can be quashed by way of a writ of certiorari. This is the connection, that if a case is pending and no order has been passed, then superior court can restrain the inferior court from proceeding further. And if some order has been passed, then by way of writ of certiorari, that order can be quashed. This is the connection between the two. Friends, the writ of mandamus is very important. And there is always one question or the other, and maybe more than one, in every competitive test where Constitution of India or the present day knowledge papers have been prescribed. In the IAS, that is Civil Services Examination, also there is in the syllabus, the Constitution of India is there, and in the Judicial Services of the state, the present day paper, which requires every examinee to have knowledge of Constitution of law. Questions are asked on judicial powers of the Indian judiciary. This power is prominently called the power of judiciary. Any order, executive, or any enactment passed by a state legislature or the parliament can be challenged before the Supreme Court or the High Court if it violates fundamental rights of the citizens. Friends, the High Court or the Supreme Court can issue instructions, mandatory instructions to any government or corporation authority to do or not to do an act which is not a legal act, or which is the authority is not obliged to act. Hence, this writ is also a discretionary writ in the powers of the High Court and Supreme Court, meaning thereby that if there is an alternative remedy, then the writ jurisdiction court will say that you first take recourse to that remedy. And the writ of quo warranto is also very important. An officer of the legal service of Assam state was appointed as a High Court judge. A quo warranto petition was filed against him with the allegations that since he was not a member of the judicial service, he was not eligible to be appointed as a High Court judge. Writ of quo warranto was issued by the Supreme Court, and the judge was unseated as his appointment was held to be unconstitutional. Friends, the next writ is that of habeas corpus. If someone is wrongfully detained by the police or by any government authority or even by a private person, then the Supreme Court or High Court can ask the authorities to produce the detainee before it, and after hearing him or her, an appropriate order can be passed, instructing the authority who has detained it to release him forthwith. Friends, it is a right to freedom, and it can be filed by the detainee or his relative or even a friend. Friends, this is all I would have discussed in time about the power of the judicial review enshrined in our constitution, decided by the High Court. And to summarize, I can say that there are 5 kinds of writ petitions. So I believe all of you might have read them, must have gained knowledge about them. But it is the most powerful strength of the judiciary which rises it to do or not, or to issue instructions not to do a thing which is not in accordance with the provisions of the law. So, friends, thank you very much for having listened me. I can take up now questions if I have time.
Thank you, Justice Mr. Singh. In fact, we're grateful for this insightful lecture, and I'm sure our students are motivated and guided, especially with your explanation of the entitlements that a judicial officer can benefit from. I will now be taking up questions,
Yes,
though there is paucity of time. What I can do is I can combine a few questions because I see that there are a few interesting questions in the chat box.
yes.
So, sir, the participants do want to know your experience when you were studying for and studying for your judiciary examination. How was it preparing for the examination? And then if you can give any tips for our students if they are appearing for an interview or the judiciary examination itself, how do they go about preparing for that exam?
Yes, see, the hard work is required. I remember when I was preparing for the Provincial Judicial Service, then it was my final year of LLM. And it was indeed very difficult to cope up with the course of the LLM on one side and then prepare for the Judicial Service examination. But I was determined to do, and I had an example. A friend of mine had cleared both, that is LLM final year examination and the Judicial Service examination in 1 year, in the same year. So I took inspiration from him. And this is what the humanity says, that one should derive advantage of the inspiration and the exemplars from other. So I studied for 18 hours a day, and I knew only the roads which from my house led to my library in the Merit College, and I devoted myself fully to the cause of LLM and Judicial Services examination. There were no coaching institutes in those days. I appeared in 1969, and 4 days after I passed the LLM examination, I was interviewed and got selected in a week. So I was the youngest in my batch, not even 24 at that point of time. I joined service at the age of 25, and since I was in my top positions, uh, after after three of my seniors, one of them was unfortunately sidetracked because of his some intolerable activities, and two of them have gone to Delhi Judicial Service. So I came to be at the top of my batch. I always got my promotions first of all. So hardworking guidance. Now coaching institutes are there, and all of them can be beneficial to the students while preparing for the judicial service examination. Lot many books are available. You go to the Jain House, Jain Jain Law Book House in the Connaught Place. I still regularly visit it and find out is there any latest book of autobiography of famous judge or famous lawyer. I go purchase them for me. So one should always be on the learning process. And Swami Vivekananda has said that once a student, always a student. Your reading should be your habit. It should be your hobby. Go on reading every time, not only your syllabus books, but also the general books, many journals, and newspaper should be your hobby, reading newspaper, because newspaper always they give the latest knowledge of happenings in the world, and the Supreme Court cases are also reported in it, so you get the latest. Yes.
Thank you so much, sir. In fact, this entire lecture was so motivational for me, my colleagues, my students, and anyone who's watching it. So, with this, we come to an end of the first lecture. And I, on behalf of JGLS, am grateful to Honorable Mr. Justice Singh for kindly agreeing to deliver today's lecture. Your Lordship, we look forward to hosting you again soon, and hopefully this time at our beautiful campus. The next
God
lecture
bless.
is yes. Thank you, Your Lordship.
Okay.
Your Lordship, this is for the participants. So the next
Ah,
lecture is scheduled to be held on 11th of September 2021 on Saturday, wherein Professor Satya Pratik will be giving an overview of the Constitution of India 1950. And this is going to be a refresher for anyone who's already studied the subject and a guide for everyone who's about to study the same in future. So we look forward to your active participation. See you next weekend. And thank you, Your Lordship, for giving us a refresher on judicial review. We're really grateful to have hosted you. Thank you.